Good morning and welcome to our seventh edition of lecture on the introduction to European law. In our previous lecture, we dealt with freedoms, and we dealt with freedom of goods, we dealt with freedom of services, and we dealt with freedom of capitals. Today, we are going to deal with freedom of persons. Under the freedom of persons, we have to understand some of the treaty provisions. For example, Article 18 of the treaty forming European Union, which bans discrimination on the grounds of nationality. Article 20 of the treaty forming European Union, which talks about the citizenship of the EU. In other words, who is considered as EU citizen. Then Article 21 talked about free movement and residence of EU citizens, while Article 45 talks about free movement of workers. Article 49 talks about freedom of EU citizens to establish in another EU country. That is Article 49 of the treaty forming EU. And also, finally, we will talk about Article 56, which talks about freedom to provide services from one EU nation to another. Are we clear at this point? If we are, then let's talk about EU treaty and EU citizenship. When we talk about EU treaty, we have to understand also the relationship between this EU treaty and the EU citizenship. We have to talk about certain facts. One, every person holding the nationality of a member state shall be a citizen of the EU. That is enshrined in Article 20 of the Treaty forming European Union. Secondly, every citizen of EU shall have the right to move and reside freely within the territory of the member states, subject to the limitations and conditions laid down in this treaty and by the measures adapted to give it effect under Article 21 Treaty European Union. Now, what do we mean by free movement of workers? This was clearly defined under Article 45 and Article 45 to Article 48 of the Treaty forming the European Union. Then, workers have the right to do a lot of things when they decide to migrate to one or other member states. One, they have the right to accept offers of employment actually made to them. They have the right to move freely within the territory of member states for this purpose of working. They have the right to stay in a member state for the purpose of this employment, and they have the right to remain in the territory of a member state after having been employed in that state. For example, if I decide to move from the Netherlands now to the Czech Republic for my firm, and eventually I live there for a couple of years or for a couple of months and decide maybe my company is not going well and I decide to close the company, I still have right to reside in the Czech Republic as long as I want. Am I clear? Now, let us talk about secondary legislations. One, the original fragmentary legislations are. We dealt with it already in, I think, in lecture 1, 2, 3, when we dealt with regulation. And now we are back to these secondary legislations, and we will deal with these regulations, directives, etc. But this time, let's talk about, for example, Regulation 1612/68, which deals with freedom from discrimination in employment. We also have a Directive 64/221, which deals on derogation on grounds of public policy, public security, or public health. This directive gives the states rights to breach citizens' rights for employment in a member state because of these three grounds I mentioned: because of public policy, because of public security, or because of public health. Let me give an example. For example, I am practicing law in the Netherlands, and I moved to Czech to practice law. And along the line, the Bar Association feels that I am helping immigrants to stay in the Czech Republic illegally, and I was charged for it, and blah, blah, blah. For if it is established that this was actually what I am doing, the Czech Republic can deny me from living in the Czech. They have to order me to go back to the Netherlands because of either public policy or public security. This is an example I'm giving. There is also another Directive 68/360, which deals on the rights of workers and their family. We briefly dealt with the rights of workers and family in our previous lecture when I said that if you're married, for example, to a EU citizen and he or she moves to another state to work, that you have the right to move with your family or your partner. And this is what this directive is talking about. So it's Directive 68/360, which deals on your rights as a family of an EU worker. Then there is also Directive 73/148 on the rights of the self-employed and their family. There is also Directive 75/34 on the right to remain after employment has ceased, just like I just explained. So these rights of the individuals were covered by these secondary legislations, regulation and directive, and I've named where you could find this your right in case you feel that a member state is encroaching on your right as EU citizen to reside in any of the EU country. Then you could go to any of these directives I mentioned or regulation I mentioned to see if your right is actually justly breached by the member states. There is also Directive 2004/38 of the European Parliament and of the Council of 29th April 2004 on the right of citizens of the Union and their family members to move and reside freely within the territory of member states. So if you're a family member of an EU citizens, you are free to move with your family to any member states you wish to. Now, let's differentiate how the relationship from being a worker to a citizen goes. who do we see as workers and who do we see as citizens? Now, from worker to citizens has a lot of different types. For example, being a worker proper, then it is clear that you are a worker. A student, an EU student who leaves his or her mother state to another EU EU country for the purpose of study is also considered as under these directives of workers. So you are covered as a worker. Also, if you are a pensioner or pensioners and you leave your member state country to go to another member state to reside, then you are also considered as a worker. Then European citizens in general, it is already your right to migrate wherever you want. Then there are people they call third country nationals or non-EU citizens. There are also people that are called derogations of rights of free movement. That is the one I said, like criminals. If you're constituting nuisance in one member state, the state could ask you, hey guy, we are done with you, go back to wherever you come from. So, who are workers? I've already told you a list of people who could claim their rights as workers. Now, let us define them exactly as the court sees them. Now, who are workers? That's the questions. One, the concept must be defined in accordance with the objective criteria. If you want to claim your right as a worker, that concept worker must be defined in accordance with objective criteria. The essential features of an employment relationship, however, is that for a certain period of time, a person performs services for and under the direction of another person, in return for which he or she receives remuneration. This was established in case 66/85, Laurie Blum versus Lambaden in Germany. Also, a worker of a member of a religious group or religious community who performs some household duty even without getting formally paid, only pocket money, has been found in case 196/87 to be acceptable as a worker. This case was between Steyman versus Staatssecretaries van Justice in the Netherlands. The case has to do with these people working voluntarily in the church. And even if the church is not paying them, but at least sometimes the church will give them some pocket money to appreciate what they are doing in the church. So the court established in this case that yes, this person could be seen as a worker. Now, other activities that could be described as work, for example, are 1. A job seeker. A person who had lost his job or her job, not currently in employment but capable of finding another job, could be seen as a worker because he or she had worked before but lost the job and is still seeking to find a new job. So this was established in case 75/63 under Hoekra versus BBD in the Netherlands. Another one, part-time workers. A part-time worker whose income does not provide sufficient support but fell below the nationally recognized minimum wage, provided that the work is effective and genuine and not on such a small rate as to be purely marginal and ancillary, could be seen also as a worker. A part-time worker whose income was below the minimum in the host member state and who needed to supplement that income from benefit funds of another member state could also be seen as a worker. This was established also in the Netherlands against, in case 13985, Kempt versus State Secretary van Justice. What they call here in the Netherlands, the State Secretary of Justice is the Justice Department, in other words. Now, another people that could claim that they are workers or claim their rights as workers are people conducting a sort of rehabilitation activity. The concept of worker does not include a person from one member state who performs work as a part of a drug rehabilitation program in another member state. Did you understand what I said now? Although people who are claiming rehabilitation rights or rehabilitation activity in one of the member states could claim their rights as a worker, the court says not everybody. If you're a drug addict and you were held by the state so that they will clean your system from your addiction, and you're from another member state, you could not claim your right as a state. In fact, as a worker, in fact, that state could actually pick you up and deport you back to your state, for your state to take care of your addiction problem. Or they could rehabilitate you, and after rehabilitation, they will declare you persona non grata, and they will send you back to your mother state or something. Yes. For example, now, a French national who lived in Belgium in the Salvation Army, where he or she is in exchange had worked for 30 hours per week, could be seen as a worker, not minding the fact that he or she was working in the Salvation Army. Salvation Army are like Caritas or Red Cross that helps poor people, blah, blah, blah. So as long as at least there is a sort of remuneration paid to you, it could be seen, or you could have rights to claim that, yes, you are residing in this member state as a worker. The work was found genuine and real, and for remuneration, therefore, that person gained status of a worker. This was established by the ECJ. So, as long as remuneration is paid in whatever you're doing, yes, you could claim your right as a worker in a member state. But you could not claim your right as a worker if you were a drug addict and the state picked you up and put you in rehabilitation. Nope, you don't fall into these protection rights of workers. Now, let's talk about a popular case, the Bosman case of number C15/93. This case is important because I love football, and this case actually opened the way for foreign players to be able to survive here in Europe, European League. And this Bosman case, Bosman is a Belgian And you guys know him. He was a popular footballer and he wanted to transfer. Anyway, I will not go into details about this case. We will discuss more about it later. But this Bosman case has some about 4 facts to be established. One, somebody they called a humble worker versus a strong system. 2, sports, economic activity, the end of transfer compensation. 3, quit training. And 4, the new FIFA regulation on status and transfer of players. You see why I told you that football lovers should try to go through this case, because this case is what made people like Mikel Obi or Osimhen, all these people that doesn't have a European passport, to play football in Europe without much stress anymore. Now, equal treatment. When we talk about equal treatment, we have to understand one thing: ban on direct discrimination, which we talked about before in previous lecture, in Article 18 of the Treaty forming European Union on the basis of nationality. Also in Article 45 of the treaty, 3 things were established in Article 45. 1, access to employment. 2, pay. 3, employment conditions. And another thing to bear in mind is that association agreements or cooperation agreements and so on could be monitored to make sure that they do not violate this Article 18 or Article 45 of the Treaty forming European Union. Now, discriminatory acts and limits to free movement. In order to get more clear knowledge about what they mean by discriminatory act or limits to freedom of movement, we have to understand what they mean by, for example, discriminatory act. Discriminatory act could mean 1, a legislative, ordinary legislation, for example, or collective bargaining agreement, or regulations of private associations. For example, in this Bosman case I said, or FIFA versus UEFA. Because this Bosman case was a case that FIFA filed against UEFA, and eventually FIFA won the case and liberated foreign players or even players from other European Union to be able to migrate to any club outside where they are playing in order to trade their profession. Now, another thing you have to understand when they talk about discriminatory act and limit to freedom of movement is also how do they limit free movement. Free movement could be limited based on public administration, public order and security, and public health, which we have talked about before. Now, let's talk about the scope. There are about 6 or 7 scopes that deals with discriminatory acts and limits to free movement. One could be social advantage attached to employment. For example, social and tax advantages accorded to your citizen and not to another citizen, another person from a different member state. There is also limitation to access to market. That is, extent of indirect and direct discrimination, which we talked about in our previous lecture. Another one is justification of restrictive measure as appropriate. We dealt with this also. Then non-discriminatory, proportionate, justifying mandatory requirements in the general interest. All this we have dealt with in our previous lecture. All you need is take your time, listen to the tape, grab whatever you need to grab. This is not your final lecture. You're still going to meet your lecturer at the uni, and when he's talking now, you will start understanding whatever he's saying, and you will be proud answering his questions, challenging him or his arguments. So our purpose is to give you this basic knowledge of what European law is about, or what you are going to encounter when we talk about European law. Now, let's talk about derogations from free movement. Derogation for free movement is actually for member states to determine concept of public policy, but not limitation on free movement of persons, has to be based on personal conduct and present threats, and have to be proportionate. Public policy, public security, public moral, respectively. I've given you an example before that I am practicing. For example, I'm practicing in the Czech Republic, and I'm from Netherlands, and because in the Czech Republic there are a lot of black people, for example, they are finding life difficult, and as a lawyer I decided to help them somehow to get their status changed in the Czech Republic, and along the line, the government feels that I am breaching public policy or public security or whatever. Because of that, they want me to go back to the Netherlands. Okay, that they could do, but the law demands them to be proportional in dealing with me. Does that warrant them to kick me out of the Czech Republic back to the Netherlands? I could have a successful argument in courts, and the Czech government might lose if they decide not to be proportionate in dealing with this kind of case. For example, there is also a case already established by the court, a case 4174, but that I talked about when we were talking about direct effect. We talked about Van Duyn case, and there is another case 6774 we talked about in Italy, the case Bonsigno in Italy. Joint cases 115 and 116/81 of Audio and Cornell, we also briefly talked about it. Now, let's see how ECJ dealt with Article 45, especially Article 45, Paragraph 4 of the Trade Reforming European Union, Public Service Exception. The ECJ offered narrow interpretation of public service work and determined that the application of exception would depend on the nature of duty and responsibility involved at that work, not on the concept of the public service. Case 149/79, Commission versus Belgium. For example, there is this news. Last time I went to Nigeria, there was some fraudsters we are spreading rumor that British government are looking for Nigeria to recruit them in the British Army. That is completely fraud. A Nigerian is a Nigerian. and cannot be recruited in the British Army or in the Netherlands Army unless he or she is already possessing a British or Netherlands citizenship. But the rumor or the spam mail was going on everywhere in Nigeria, and everybody was trying to find a way to jabber, and this person, whoever was posting that kind of message, was looking for people to dupe. Guys, you cannot be enrolled into the British Army unless you are a British citizen. You cannot be enrolled into Netherlands Army unless you are a Netherlands citizen. So don't let them defraud you. Now, we have talked about this, and it is clear to us that the court established, although did not interpret in a wide or a wider, or he did not offer a wider interpretation of who could be employed in public service. The state needs to use their discretion while doing this. In fact, this is where the state could strongly use public policy or public security to refuse another member state from working in their public service, and then you need to protect your national security. You cannot expose your national security or national intelligence to foreigners. There is a simple fact. So when a state rejects you from working at the police office or military, you cannot take them to court because they have solid reason for doing that. They need to protect national integrity and national interest. So we are back again to Directive 2004/38, the scope of it. This directive is talking about family of EU citizens. This directive applies directly only to EU citizens who moves to or resides in another member state and their family member. The scope of it is 1. The right of the EU citizen's family member applies irrespective of their nationality as long as the claim of primary entry and residence rights is made by the EU citizens. Let me explain to you what I mean. I am EU citizen. My wife is a Nigerian, and I took her to the Netherlands, for example, to live. The Netherlands authority must, the same rights they accord to me, they must accord it to her. But she cannot leave me here and go to the Netherlands because she is my wife, and tell them, hey, I'm the wife of Barrister Gabe and I want to live here. Automatically, Netherlands government will send her back to here, for example. Another scope could be that freedom from discrimination on the basis of Article 18, which means nationality, transposed so that all EU citizens and their family exercising residency rights under the directives. So it's like I or the EU citizens is the bag carrying his non-EU citizens to any member state he or she wants, and the law, the same rights the law gives to him or her, they will accord to his family who are not EU citizens but are proven to be his family members. They are also protected under the Directive 2004/38. The rights of EU citizens family member applies irrespective of their nationality as long as the claim of primary entry and resident right is made by the EU citizen. Secondly, permanent residency granted to all EU citizens and their family members, regardless of their nationality and economic status, who have resided legally in a host country for at least 5 years. This is under Article 16 of the directive. Thirdly, safeguard in relation to member state rights to expel individuals on grounds of public policy or public security. Freedom from discrimination on the basis of Article 18 transposed so that all EU members or EU citizens and their family exercising residency rights under the directives are entitled to equal treatment with the national of the host. This is under Article 24 of the directives. New administrative procedure and requirements related to reporting requirements and resident cards. Now, let's see how ECJ defined EU citizenship. Application of non-discriminatory principle to EU citizens. Case C-8596, Sala versus Freestad Bayer in the ECJ. An EU citizen lawfully resident in a member state of which he or she is not a national can rely on the non-discriminatory provision of Article 18 in all matters falling within the scope of application of the treaty. So this right has a direct effect, and the individual could claim it with no stress. As it is established in this case versus Sala versus Freestad Bayer. Another case was case C-184/99, Grizelzik versus Central Public. This was in, I think, in Poland. The EU citizen student lawfully residing in another member state not to be discriminated against on the basis of their nationality when considered for welfare benefits. So this was like a Polish student who is residing in Netherlands decided to go to the welfare office to claim for financial support or something, and he was rejected by the Netherlands. And the ECJ is telling the Netherlands, no, as long as it is proven that this person is a Polish citizen, for example, and is studying in the Netherlands, that he or she has the right to come to the social welfare in the Netherlands to seek aid. I think it's getting a bit clearer in this 7th lecture. Do anybody have a question? If not, I urge you to take your time, go through this lecture once, twice, third time, and things will start flowing properly. And by the time you meet your proper lecturer at the uni, you will be one of his best or his favorite students. My name is Gabriel. My duty here is to make you get your A or your B in your Introduction to Law, Introduction to International Law, and Introduction to European Law. I thank you for today's lecture, while I see you next week for the 8th lecture on the Introduction to European Union. Thank you and have a nice weekend. Bye.